Eleonora Rosati, who is Professor of Intellectual Property Law, co-director of the LLM in European Intellectual Property Law. Welcome, Eleonora. We have together with us Georgios Glossiotis, Librarian, Knowledge Rights 21, National Coordinator for Greece and Cyprus. We have also, welcome Georgios, we have also Kacper Szkalej, who is researcher in intellectual property law at the Institute of Information Law and at the University of Amsterdam. And we have also Bergman-Tahon, who is director at the Federation of European Publishers. Welcome all of you. We are thrilled to have you with us for this webinar. We can start. Of course, we are first expert. Eleonora Rosati, welcome.
Hello and good morning, everyone. I will start sharing my slides, but I guess to this end, you will need to stop sharing yours, Daphne.
Of course.
Perfect. So, hello everyone, and it's a pleasure to be here this morning. In the time at my disposal, I will be presenting some remarks about the main requirements for and rights granted by copyright in order to set the scene for the subsequent discussion. Specifically, I would like to touch upon 4 points. The first one is the question of what copyright is and what it does protect. Second, when copyright protection does arise, what rights are granted by copyright, and then the final and perhaps most practically relevant question, how you can comply with copyright law and related restrictions. So let's start with the first question. What is copyright and why copyright does exist? In response to the latter, a basic answer might be that copyright is the legal shape of creativity, and that is because of the objects of copyright protection. Copyright does protect books, does protect music, does protect art, and so on. But copyright is also fundamentally an instrument of technological governance. And since its very inception, it has been indeed closely connected to technological advancement. Just think that modern copyright laws were born to answer the challenges that the invention of the printing press had brought about. Indeed, prior to this invention, to make a copy of a book would require several months, if not years, and all of a sudden it will become cheaper and quicker to make copies. So the question of how to control the making of these copies became very pressing, and that's why copyright as the right to control copies was born. And since then, copyright has been always linked to technological advancements. I'm sure that you all are aware of the discussions that are currently unfolding around artificial intelligence. You will have read that indeed there is the question of training of AI models on authors' materials, the question of outputs, whether they are protectable by copyright, whether they might be infringing someone's rights, and so on. But throughout history, that has always been a constant. And indeed, this photograph of Oscar Wilde that you see on the slide is an additional testimony to all of this. This is a photograph that was at the center of an important late 1800s US Supreme Court decision, in which the key issue was whether photographs, which at the time were indeed a new form of creativity, could be protected by copyright. On consideration that it might be an altogether different process, also from a creative standpoint, compared to other artistic works such as sculptures, paintings, and so on. The answer of the US Supreme Court was that photographs could be protected like any other work, and today no one would question this conclusion. But nevertheless, there are parallels with the discussions we are seeing around artificial intelligence and indeed the protectability of these outputs. So copyright is, yes, the legal shape of creativity, but is also closely connected to technological advancement. And if you ask indeed Google's Gemini what copyright is, you get a fairly accurate description. So it is a right that is given in the first place to creators, and that is indeed a fact that authors of works are usually, but not always, the first owners of copyright, and that protection is premised indeed on the creation of something that technically is a work and is sufficiently original. Then, as you can see, among the key aspects of copyright is that it grants exclusive rights, which I shall discuss in a moment, and that the protection is automatic. That is absolutely important. Copyright is a free right. You don't need to register anything for the legal right to be present. It arises automatically upon creating an original work. So this is both a blessing and a curse, because while you don't need to register anything, you may not know if you have an actually protected material until you test it. Then we also get the information that the protection is limited in time. Currently in Europe and in other jurisdictions around the world, such as the US, the duration is set at the life of the author and 70 years after their death. But the term may be different depending on the jurisdiction. The minimum one is life plus 50. So, bottom line, copyright is a form of intellectual property. It protects a work that is sufficiently original and has been created by someone, and it has a duration that is extended to the life of the author and a number of years after their death. So, as I said, copyright does arise automatically, and no matter what country you operate under, you have three key requirements that need to be fulfilled. First, there must be a work. A book is a work, a piece of music is a work, a sculpture is a work. What copyright does not protect is simple ideas, and that technically is known as idea expression dichotomy. So there must be a work. Second, there must be someone who has created that work, and that is known as an author. And third, there must be sufficient originality. These are the three main requirements. Then, depending on the country and the type of work, you might have, as you can see from the slide, additional requirements, which now we'll not discuss in any detail unless there is a specific interest on your side. I suggest instead we focus on two of these main criteria, and specifically the notion of authorship and the notion of originality. So, as I said, an author is the creator of a work, but it is not always required that this author materially makes a work. The author is the person in charge of the creative process. And this French case involving a famous contemporary artist, Maurizio Cattelan, is, I think, quite telling. So Maurizio Cattelan, as I said, is a famous artist, but is not the material maker of all of his works. If you take some of his best-known artworks, such as La Nona Ora, representing Pope Wojtyla, hit by a meteorite, is not something that Cattelan materially made. He had a craftsman, Monsieur Drouet, who realized this work for him. Then Drouet sued in France to obtain a judicial recognition that he would be author or at least co-author of this work. But in the end, he was unsuccessful because, bottom line, the author is the person in charge of the creative process. If the material executor of a work indeed simply executes someone's creative instructions, is not an author in a legal sense and does not have any claim under copyright law. And that, I think, also is a useful guidance in the context of artificial intelligence. As I mentioned, there is increasingly indeed a discussion about whether and to what extent AI-assisted outputs can receive protection under copyright. There has been also the release of guidance, for example, from the US Copyright Office, as you can see on this slide. Bottom line, I would say that the rule of thumb is that AI-assisted outputs can receive protection insofar as it is possible to identify an authorial contribution of someone. So what is key is that a person is in charge of the creative process and artificial intelligence is used as a tool to aid a human-led creative process. So that is what an author is, and this is a notion that, despite being at the basis of copyright protection, still raises interesting questions, as you can see. Then we turn to originality, and in Europe, this has been at the center of plenty of litigation. It is an issue that perhaps is not fully clarified, as the number of pending cases does also demonstrate. But generally speaking, it can be said that a work is regarded as original and therefore okay for the sake of copyright protection if it is the result of choices that need to be both free and creative. So you need both freedom and creativity. If one of the two is lacking, the legal test is not met. And indeed, this image that you see on the slide is, I think, a telling example. So this is taken from the website of a museum, and it is the digitization of a public domain painting. By public domain, I mean something that is no longer protected by copyright. As you can see, the painting was realized in the 1800s, so any copyright vesting there has lapsed. But the museum, as you can see from the image, claims that there is a copyright in the digitized image. Is that an accurate or truthful claim to make? It is questionable. Why? Because this digitized image seeks to be as close as possible to the actual painting. So the choices made in the realization of this image are technical, they are not free and creative. If this digitized image was distorted compared to the painting, added some new elements, etc., then the considerations might be different. But if it is a close replica to the painting, then it is doubtful that it will be regarded as original in a copyright sense. So, to have something that is protectable by copyright, you need both freedom and creativity. A corollary of all of this is that choices that are purely technical are not eligible to confer originality and therefore to attract copyright protection. Turning to the rights granted by copyright, they in essence belong to two main groups, moral and economic rights. The former are rights that in essence safeguard the personal connection between an author and their work. Since in many countries copyright is regarded also historically as a natural extension of someone's personality, that is why these rights receive legal protection. Economic rights relate instead more to the economic dimension of copyright and economic exploitation of a work. So, what can we say about the moral and economic rights? That the former, in essence, safeguard, as I said, the personal connection, and the latter relate to the economic exploitation. In terms of differences from country to country, moral rights remain quite different also across Europe, while economic rights are more or less the same everywhere across the European Union 27 member states. And there has been also an harmonization of related exceptions. So the catalog may be different from country to country, but the relevant concepts are very similar between Greece, Italy, France, and all the other member states. So a bit more of zoom on these rights. Moral rights are personal rights of the author, and that in turn means that they are non-transferable, so they always remain with the author. We shall see in a moment that there might be a way to make this statement less true, at least in practical terms rather than theoretical. But in essence, these are personal rights of the author because they safeguard this personal connection that I have indeed detailed. And while you may have different moral rights depending on the country, at the international level there are two basic moral rights that need to be recognized. The first one is the right of attribution. You may find it referred to in some older text as a paternity right, but I will find it more correctly to refer it as a right of attribution. It is the right to be recognized as the author of a work. And then there is the right of integrity, that is the right to object to any distortion, mutilation, or other modification or action that may be detrimental to the honor or reputation of the author. So, for example, derogatory treatment might be making a pornographic version of a book. This would be something that an author could object to. And the fact that moral rights are different from country to country also shows the importance of having these differences well clear in mind. That you see on the slide is indeed a representation of a famous French case in which a director of a film was able successfully to enforce his moral right of integrity over the unauthorized colorization of a film that he had realized. This outcome was possible in France due to the generous protection of moral rights, but would have been hardly achievable in other jurisdictions. Turning to economic rights, as I said, these have been harmonized to a much greater extent, both internationally and across the European Union. And they entail the right to control the making of copies of a work, the right to sell these copies, the right of rental or lending. So, for example, for libraries to operate, they need permission from the publishers who own the copyright to the books that are indeed given to patrons of the library. Same thing if you want to perform a play in a theater, that will be a public performance issue, and so you will need permission from the relevant copyright owner. Same thing for a streaming platform to make available someone's film for viewers to watch, they will need permission from the relevant owners of the rights to the film. Same thing if you want to make an adaptation of a book and turn it into a TV series, you will need the permission of the copyright owner. So these rights are indeed belonging to the economic rights family, and all these activities that I've just described can be undertaken directly by the owner of the copyright or by someone else with their permission. And then there has been, of course, also the harmonization of exceptions to economic rights. I've spoken of permission that you need, but this is not always necessary. And indeed, there might be situations in which you can rely on an exception. If you want to quote someone's work, short extracts of someone's book, in principle, you may be able to do that by relying on the quotation exception. If you want to make a parody of someone's work, there might be an applicable parody exception that allows you to do that without permission. The reason why exceptions do exist is because the law does recognize that copyright is to be fairly balanced against third-party rights and interests that are also of importance, including freedom of expression. Coming to a conclusion, how can you comply with copyright laws? First of all, it is important to bear in mind that the ownership of these rights can belong to different subjects. As I mentioned, the author of a work is in principle the first owner of the copyright, but that is not always the case. Indeed, it might be through contract that, for example, an article that you write as part of your job is protected by copyright and you are technically the author, but your employer and not you owns the copyright. Or you might have doctrines like work for hire, that is a typical US doctrine in which indeed the legal person who commissions the making of a work is also deemed to be not just the copyright owner, but also the author of the work. So first, you need to check on who the owner of these rights is. Then there might be situations in which there are contracts in place. And here you need to have very clear in mind the difference between different types of contractual instruments. And the main ones are license and transfers. A license is an instrument that allows you to retain the copyright over your work and authorize someone to do an activity that copyright does restrict. Example, make a copy of your work. A transfer or assignment is instead a situation in which you give away the ownership of your copyright. And because of these effects that are much more pervasive and extensive than a license, many countries do require that transfers to be valid are to be done in writing. I also mentioned that you can get away the application of moral rights, and that technically can be done through a waiver, which is an obligation that an author does assume not to enforce their moral rights against their contractual counterpart. Whether waivers are enforceable or not is a matter of discussion, and there are some countries in which the answer might be in the negative. And then, last but not least, there are also exceptions which I've mentioned, that is the possibility to undertake activities that copyright does in principle restrict without the need for authorization. In Europe, you need to check whether in your country's copyright law there is an available exception that might cover the activity that you have in mind, and if there is, what the relevant requirements that need to be fulfilled are. So I hope that I've not exceeded too much the time at my disposal. I thank you for your attention, and if there are any questions or comments, I'm very happy to take them before I pass the floor to my fellow presenters. Thank you very much.
Thank you very much, Eleonora, for your valuable perspectives
I
and
see that there is a
information.
question from Constantinos. Does the moral
Yes.
integrity lapse after the death of the author? Here the answer is it depends on what country you are considering. There are countries in which moral rights are perpetual. That is, for example, the case of France and Italy in Europe. Then you have countries in which moral rights last as long as economic rights. So life plus 70, for example, in Europe. That is the case of the United Kingdom, it is the case of Germany and Austria, just to provide a couple of examples. So it depends really on the country that you are considering. But internationally, we are speaking of a duration that is at least the same as economic rights. But also here there are exceptions, because in the US, the very thin layer of moral rights protection that does exist is also subject to a term that is even shorter than the one of ordinary copyright. So in copyright law, the right answer is always it depends. For moral rights, that is even truer.
Thank you very much. Would anyone like to ask a question? Any other question at this point? Okay, we can move forward with the second. Oh, if there is one question. We cannot hear you, Eleonora. You are muted.
Sorry. If we would like to make a phonogram from a folk tale which was published in 1985, do we need permission? If the folk tale was published in 1985, then I suspect that permission might be required. But again, it will depend on the specificities of the case in question.
Thank you. Thank you very much. If there is any other question, you can, of course, place it in the chat. We can move forward with the second part, understanding copyright for libraries. And we are, thank you, Eleonora. And we are welcoming Georgios Glossiotis, who will present the e-lending rights, systems, and practices in Europe. I am sharing the presentation. Okay, Georgios, the floor is yours.
Good morning to everyone. Thank you for the invitation here. And I would like to present you what is happening in Europe right now with e-lending. Before doing that, next slide, please. We should to discuss about some fundamental rights for the citizens in Europe and not only in Europe. We have the Universal Declaration of Human Rights in the Article 19, which everyone has the right to freedom of opinion and expression. The rights include freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. This is a basic right. More rights in the Declaration of Human Rights are respect of dignity in human beings at Article 1, confidentially in Article 1, 2, 3, and 6, equality of opportunity in Articles 2 and 7, privacy, 2, 3, and 12, freedom of thought, Article 18, development of and dignity, Article 22, education, Article 26, science and the cultural life of community at Article 27. Plus, to this Declaration of Human Rights, we have some texts in the European level. We have the Charter of Fundamental Rights of the European Union, where in Article 11, everyone has the right to freedom of expression. The rights shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. Next slide. Next slide, please. Why I did this introduction? Because fundamental rights have to do with libraries' operation and the role of libraries in society. Public access to information enables people to make informed decisions that can improve their lives. Communities that have access to timely and relevant information for all are better positioned and eradicate poverty and inequality, improve agriculture, provide quality education, and support people's health, culture, research, and innovation. Those are some of the Sustainable Development Goals by the United Nations, and especially in the goal 16 of SDGs of the United Nations, there is a promote of peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. Libraries are there to guarantee inclusive societies and democratic societies. Next, please. And we move one step further. We go to public lending right, PLR, and the connection with libraries. Libraries have, as we saw already, libraries have an essential role in promoting equitable access to information and culture. And lending is central to this. Without lending, libraries can't perform. While it is important to support authors, there is no firm evidence that library lending causes harm to them. Libraries act as useful distribution and discovery channels for authors, and not only. So PLR schemes should not undermine the work of libraries by reducing available resources. Those are to be considered when we are thinking about e-lending for e-books. Next, please. So in the European framework, we have the Directive 2006-115 about on rental rights and lending rights. on a certain rights related to copyright in the field of intellectual property. There we have the Article 6, where member states may derogate from the exclusive right provided for in Article 1 in respect of public lending, provided that at least authors obtain a remuneration for such lending. Member states shall be free to determine this remuneration, taking account on their cultural promotion objective. Member states as well may exempt certain categories of establishments from the payment of this remuneration. So we have recognized in European Union law that public lending right, PLR, is valid with a remuneration to the authors. Next slide, please. According to that, we had a very important court decision for the European Court of Justice, the number C174 of 2015. In this decision, in this case, the judges had to balance between a library and a provider. At the end, and under the light of Directive 2006/115 of the European Union, the judges conclude that this directive covers the lending of a digital copy of a book with two conditions. One is the lending is carried out by placing that copy on the server of a public library and allowing a user to reproduce that copy by downloading it on his own computer. And the period of the time. The second condition is the period of time. That this is for a period to have expired. The download copy would not be longer used by the user. So with that decision, the court says that PLR is for ebooks as well, with two specific conditions. Next, please. But in reality, what is happening right now? In copyright law in printed world, libraries are able to acquire any physical item because of what is known the exhaustion of first sale doctrine. After they buy, libraries acquire books, the copyright, there is exhaustion, and the libraries, other specific rules of Article 6, can lend the materials. The lending is regulated by copyright as an exception to the monopoly rights of law grants right holders. Those two provisions, exhaustions and the legislation lending exceptions, have a key public interest function and allows library to operate in the society. However, in the absence of a proper implementation of the previous decision of the European Court of Justice, there are some problems arise. One of these is that the acquisition and lending regulated by contract law and not by copyright law. That means that everything depends on whether and what the publisher is willing to offer. Next slide, please. In practical, what does that mean? Key library functions in support of a public interest goal are undermined. E-lending, interlibrary loan, and resource sharing. Whoever use library, especially in academic and research institutions, knows that interlibrary loan and lending is one of most crucial sources of information. So the first problem here is that libraries can implement their own legally mandated policies for their collection, must operate in the space allowed to them by platform or right holders. The libraries can't form anymore their collection according to the needs of their communities, of the communities they have to serve, but rely only to the availability by the platforms. So the decision around ebook availability is not only a cost, to take account of the cost. We need to discuss about non-availability of ebooks on individuals, libraries, and societies, and what does it mean for a democratic society. Further, uneven implementation of the EU framework in member states creates inequalities of provision to European patrons. Different citizens in different EU member states have different rights in access to information, and this is a problematic. We will see further how this uneven implementation creates inequality. Libraries are not able to promote e-lending to wider audience beyond early adopters, promote long-term market growth. Libraries act as market growth. They help markets, they help sales, they help the field to be increased. And at the end, it's not to think about that is the risk of preservation, the risking at 21st century black hole. If libraries can't have stored, preserve copies of ebooks, there will be a gap in e-shelves in the future. This is very crucial for curating, for preserving the written information, the written collective memory of the societies, and for the culture of the Europe. Next slide, please. Let's see some examples of member states. I will begin with the case of Greece. We have the law 2121 of 1993 for copyright, as amended and enforced by other laws anyway. There it is stated that public lending is allowed to institutions that are open to the public and not for profit, with two conditions. The borrowed works must have been legally published, and be in the legal possession of the library. For the remuneration of authors and publishers, the Greek law states that school and academic libraries are exempt from the obligation, as provided by paragraph 3 of Article 6. For other founded only for publicly founded libraries, there is a remuneration to the relevant collective society of Greece. In Greek law, there is no provision of the type of material, print or digital. There is just the word work. So under the effect of Court of Justice decision, we can move to a logical conclusion that law covers public lending of books in Greece under the remuneration stated before. But, next slide, please. The complication of copyright and the use of information of ebooks prevent libraries of offering services. In Greece, we have only the electronic reading room. It's a lending services provided by the National Library of Greece. It began operating in November 2018 as 2 years pilot project, the duration of which was gradually extended until today. Today, within the database of this e-reading room, there are 2,600 titles from 15 publishers. There is direct negotiation between the National Library of Greece and the publishers, for which the books will be allowed to be included into the reading room. The National Library prepaid publishers a flat fee of 23 euros per book copy for 2 years, allowing 36 loans per copy. This amount includes 20 euros copy cost paid to the publisher, direct to the publishers, and 9 cents to adopt DRM usage fee per loan, paid either to the Adobe DRM service provider in Greece or directly to the publishers if they have their own Adobe DRM solution. The total cost per ebook loan for the National Library is 65 cents. The model in Greece is 5:1, 5 users per ebook. This started as a pilot project, and thanks to this pilot project, when COVID period came and everyone was in their houses, this service was very crucial for people have access to literature, have access to reading materials. And in that case, we realized the importance of the existence of a public e-lending services through libraries to people, to their patrons. Next slide, please. The next case is from Finland. We have a new law in 2025 in Finland, where when a public or a university library makes an e-book or the e-audio book belonging to the library, and this is crucial here, belonging to the library collections, available to the public. And here came the law and says, on terms agreed with the publishers or other right holders. So after that, the libraries in Finland can offer e-lending right with a remuneration direct to the author, and not withstanding with the agreement between the author and the publisher or other right holders. But we have those agreed with the publisher or other right holders, something which is not provided in the Court of Justice decision. There is no provision there that publishers or other right holders should be agreed when something belonging to the library collection. The Court of Justice was very clear. Article 6 of the directive is implemented for e-books and e-lending. Next slide, please. The next case is from Germany, and we can see here how different implementation of this directive for PLR create inequality among European citizens. The regulatory system of German copyright law differ considerably from that of the European law. There is no explicit legal permission in Copyright Act on the basis of which libraries can make e-books available in a legal, secure manner. Libraries that want to offer e-lending need to license to do so. The current licensing practice means that libraries can only lend some e-books. There is not in their choice which book they will offer in their services. With a time delay, sometimes after 1 year of the publication, and a large part of their holdings cannot be lent as e-books at all. This is the reality in Germany. Next slide, please. What does this, the evidence say? We have mixed message around the impact of e-lending on sales. A German report suggests that there is a cost, but they not consider wider societal cost. Uses extensive extrapolation, speculation, looks just at the short terms. Libraries underline potential sales gains from greater availability of e-books. But this we need to stress it is that in many markets, smaller publishers are active in working with libraries in order to make e-books available, recognizing the win-win situation where a small library with not with availability of big communication channels in their hand can probably only through libraries come to audience and grow its business model. This is come to contrast with the position of larger organizations and professional associations. We know that a lot of small publishers are actively work with libraries around Europe. Next slide, please. Is a legal case for access. A teleological interpretation of the right to land, drawing human rights principle as we saw, will open up possibility to digitize physical books and libraries. We know that the act of e-lending is not communications to the public. It's e-lending, it's lending, it's PLR under the Article 6. But libraries are often unable or unwilling to take a risk around copyright. Librarians are not legal experts in copyright law. And they are not sure what is allowed or not. So the need here is to clear reassurance in law, in European level and in EU member states, implementing common rules for e-lending e-books in European citizens. Next slide, please. E-lending represents a logical continuation of the role of libraries. Libraries are there to lending materials. E-lending is the logical continuation. Market factors have a role. Yes, they have a role, but they are only one of a number of considerations. We need to take account of external. We need to take account of societies, of people, of civilians. Current licensing models are not delivered in many countries because of what happened with contract law instead of copyright law, instead of implementation of court of justice decision. In some countries, we don't have at all licensing models for delivering and e-lending. And where in some countries there are positive situation in this field, we are not sure of what will happen tomorrow. Europe needs to offer basic guarantee of the ability to acquire and lend as a basis for negotiating more balanced deals that best meets right holders and library needs. And when we are talking about libraries' needs, we are talking for the needs of their patrons, not the needs of the institutions by themselves. The libraries have no needs. The patrons, the communities, people have needs. And when we're discussing about library needs, we're discussing about people's needs and people's rights. Next, please. And I would like to finish my presentation here with the opinion of the Advocate General delivered on 16 of June 2016 in the above-mentioned case of the European Court of Justice. From an advocate, not from a librarian. Libraries are one of civilization's most ancient institutions, predating by several centuries the invention of paper and the emergence of books as we know them today. In the 15th century, they successfully adapted to and benefited from the invention of printing. And it was to the libraries that the law of copyright, which emerged in the 18th century, had to adjust. Today, we are witnessing a new digital revolution, and one may wonder whether libraries will be able to survive this new shift in circumstances. The Advocate General stated that it was a big opportunity to help libraries not only to survive, but also to flourish in the new technological environment. Thank you very much.
We can continue with our third expert, Kacper Szkalej. Please, the floor is yours. Thank you very much.
Thank you so much. I'll set up everything here. Yeah. Now you should be seeing my
Yes.
presentation. Wonderful.
Yes.
Right. So thank you so much for inviting me and for being able to participate in this debate. As was mentioned, I'm a researcher at the University of Amsterdam, and I would like to sort of continue on Georgios' track of understanding copyright for libraries and zoom into a couple of other copyright exceptions, but also an interface with licensing or the need to negotiate. And then finalize with a couple of insights on what is known as a secondary publication right. But this is not an EU legal creation, but exists in a couple of member states. But hopefully there will be some benefit to be derived from that as well. So zooming out a little bit, libraries, you could say, occupy a special position in the copyright landscape. They're public institutions, public interest institutions that are designed to serve knowledge, culture, and education. But in the copyright system, they're also users of protected content. And this dual role means that libraries must navigate between exercising their prerogatives or rights under copyright exceptions, a little bit as already has been hinted by both Eleonora and Georgios, but on the other hand, to negotiate licenses or access or specific uses, meaning that they need to engage with various categories of right holders that hold content that is of interest to the libraries or the institutions that they are attached to. There are, of course, a number of different licenses, direct licenses or collective licenses, or even so-called extended collective licenses, where particular types of copyright organizations, they're often known as copyright management organizations or rights management organizations, have the capacity to represent a collective of right holders in a number of member states, also in cases where they are not represented by the organization formally. This is the idea with the extended collective license. So the way in which a balance is achieved is quite critical between various mechanisms, both the exceptions and then the need to license, and sometimes these two also interact. It goes both ways. Too much reliance on licensing may limit access and mission-driven activity. At the same time, exceptions may be too narrow, or they may be subject to legal uncertainty, so requiring the need to complete the use with a copyright license. So it's really the building blocks of operations, so to say. Now, it's already been clear what these are. LNEs, or limitations and exceptions, are, well, essentially they're statutory permissions that allow the use of copyright protected content without the need to obtain permission from the right holder. They are essential for libraries because they're intended to mediate between different interests, private rights and the public interest, for example. There's a very strong connection to fundamental rights or human rights as well. So they're really that function, they perform that function in the copyright system to reach a balance. However, in the EU, they're part of an exhaustive catalog. So that means that member states can only adopt those copyright exceptions that are itemized or that have been adopted by the legislator. So in other words, the main forum for discussing copyright exceptions really is the EU level. It does take place nationally as well, which has to do with the type of instrument that normally, where normally copyright exceptions are adopted. So whatever happens at EU level, it's then taken to the national level, where there is still some room to discuss the particular formulation of a copyright exception. Now, with this said, there are a couple of changes that are taking place in the exceptions dimension. And one is that the CJEU, Court of Justice of the European Union, has recognized that there may be a need to interpret these provisions in a way that recognizes the very objective or the purpose of the provision. So one can say a switch from a textual interpretation, looking at the literal wording, to asking what's the purpose of this provision? Can this purpose be achieved with this provision or not? So basically opening up for a little bit more flexibility into how to view these provisions. And there's a couple of cases that confirm this. And moreover, there's been quite a explicit, I would say, recognition of exceptions as user rights. That is perhaps more of an academic question, but at the same time, it has caused a debate as to whether copyright exceptions perhaps deserve stronger treatment than what has been traditionally the case in an offline world. In the digital world, where the balance is entirely different and uses are entirely different, sometimes purely forced by technology, there may be an approach that is required, or maybe need for a slightly different approach. And with this foundation, importantly, that the change is taking place, I think we can consider a couple of particular provisions that were not mentioned by Georgios. These are I don't think this list is really exhaustive. There are a lot more. Eleonora has also mentioned quotation, which is quite significant, but there's a couple of provisions that are relevant in the library or cultural heritage context. Of course, the purest one, which is making it possible for libraries to carry out reproductions, which is in the Information Society Directive, the possibility to carry out reproductions and making available for illustration and scientific research purposes, also in the InfoSoc Directive, making available of works or quite broad uses on terminals on the premises of the institutions, certain uses of orphan works, and the more recent ones from the DSM Directive, now from 2019, cross-border use for educational purposes, preservation of cultural heritage, use of out-of-commerce works, and then text and data mining for scientific research. And these newer ones, so the last four, I think clearly demonstrate that there's a step that wants to be taken forward by the legislator to modernize copyright for the digital realities. It's not always easy to implement, and those of you who have ever been in contact with lawyers will know that, it's a directive, so it can go slightly in different directions. The old provisions, such as those at the top of the slide here from the InfoSoc Directive, are they are discretionary to implement. So not every member state has a scientific research exception, for example. That's really a political question at national level. But the newer ones in the DSM Directive are essentially obligatory to implement. So say they do exist or should exist in the national context in one way or another. And I thought I could briefly consider the last three, since they raise a couple of interesting questions on the intersection of use and licensing, and then a couple of related aspects. Preservation of cultural heritage, Article 6 of the DSM Directive. So this is an exception that, it's an exception to the right of reproduction. So the copying right, it covers all copyright protected content, including software and databases, on condition that they're permanently in the collections of the institution. Now, it's possible to rely on an external service to carry out this preservation. It is a mandatory provision in the sense that in contractual relations, it cannot be contracted out. So in copyright discussions, we normally see this as a very strong signal that the copyright exception is intended to be entrenched. It is intended the beneficiary should be able to rely on it. Now, one particular aspect that sort of comes to light here, what does preservation actually mean? I think I would assume that in archival and library studies, this is fairly obvious. As lawyers, we always need definitions, and unfortunately, the DSM Directive does not really fully resolve that question. What we do know is that it is clearly an exception to the right of reproduction. But, if you preserve, why would you preserve if you can't make it available? So that's really, and that can potentially activate another right. So there is a little of a sort of a gray area here, but looking into it's the preamble of this directive, the preamble does recognize in point 25, or as we call it, recital 25, that cultural heritage institutions are engaged in the preservation of their collections for future generations. So if this is the objective or a component of preservation, one can really ask if that sort of implies a possibility of those future generations to actually be able to access the preserved information. And in order to access, one must, of course, have the means, or the library must have the possibility to ensure that form of access. So I think that there is some room to discuss the scope of this provision, because even if it is, at least according to the text of the directive, clearly an exception to the right of reproduction, the very act of preservation sort of assumes that this information should, or it is carried out for the purpose of being available for future generations. So that, of course, since the as this recital 25 shows, also it's a quite a long text, of course, but it recognizes that essentially any technique is possible for the purpose of preservation. One can ask the question, well, can a library simply make available its collection online openly? I think that the initial answer to this is that no, they cannot. But given the objective of a preservation exception or provision, I think that there is room to discuss this actually. Then there is another aspect. So I have it as my last point here. Is it a portal provision? When a library carries out acts of preservation, well, it may seize the opportunity to carry out or to collect the information in order to create a database, let's say, for the purpose of allowing text and data mining, which can raise questions. Well, is it allowed to rely on one in order to make another possible? And I think that the answer here is pretty fair and straightforward. That's coming from recital 27 towards the end, that acts of reproduction undertaken by a cultural heritage institution for purposes other than the preservation of works and other subject matter in their permanent collection should remain subject to the authorization of right holders, of course, unless permitted by other exceptions or limitations provided for in union law. So if there's a sort of dual purpose that on the one hand, well, we're preserving because we're a cultural heritage institution, it's our job. At the same time, we will seize the opportunity to create a data set or a database out of this material to allow our staff to rely on other copyright exceptions. It seems that it is not precluded by this framework to do it, because the actual later legal use is governed by another provision that already exists in the system. The use of out-of-commerce works is also particularly interesting and worth highlighting. What is this? It's not defined in the section on the terms, but in Article 8.5, out of commerce work is a work or other subject matter. It shall be deemed to be out of commerce when it can be presumed in good faith that the whole work or other subject matter is not available to the public through customary channels of commerce, after a reasonable effort has been made to determine whether it is available to the public. Now, this, of course, requires some degree of due diligence. At the same time, copyright is national, so a library or a cultural heritage institutions is, of course, not required to look into every potential channel of commerce available anywhere in the world. The way copyright markets work is normally through some sort of fragmentation, which is done for efficacy reasons or business reasons or various other reasons. But essentially, the interesting aspect here is that a cultural heritage institution can obtain one of the extended collective licenses from a collective management organization for the use of out-of-commerce works. And the provision confirms that it's full coverage, so any right that may be involved, including making available. This is, of course, very good from a theoretical perspective. There can be situations where CMO, the way this is defined in the directive, is that it needs to be a sufficiently representative organization of particular categories of right holders, which is quite normal for collective rights management. It may happen that there is no such organization, or that it doesn't recognize itself as being sufficiently representative. That is really up to interpretation, but the directive foresees a sort of safety net in Article 8.2, which is that if there's no relevant collective rights management organization, the cultural heritage institution may make available and reproduce for non-commercial purposes out-of-commerce work permanently in their collections. So that is in case there is no other option. Now, for the purpose of making available online, for example, this kind of works, Article 9 of the directive confirms that the acts that take place for the purpose of copyright analysis are to be deemed as taking place in one location or the member state of operation, essentially. So the fact that it's even reachable elsewhere should sort of not preclude this provision from operating. Now, there is a sort of third, one could say, or concealed aspect here. What if there is a CMO that is sufficiently representative, but it refuses to issue this kind of license? The directive does not force a CMO to issue a license, so the act of refusal is sort of, well, it's not illegal, it's just surprising, because the system assumes that if you have capacity to do it, of course you will do it. But in case that happens, well, there is no really easy way around it, except, of course, submitting a formal complaint. There is usually a supervisory authority, and well, stepping outside of the comfort zone and alerting that, well, the system assumes that we can do this. Unfortunately, we cannot obtain a license, but it does consider itself to be sufficiently representative. So it's really in between the provisions. And well, it seems that some degree of risk taking may be necessary here, but the important thing is to really maximize the benefit of this provision. And well, suing is not an option in terms of formal proceedings, but initiating a complaint toward the supervisory authority seems to be an option to sort of at least determine what could be a potential way forward. Lastly, then, what I wanted to highlight, the text and data mining provision for scientific research in Article 3 of the DSM directive. Now, this is, of course, more relevant for the researchers doing the work. Well, staff of cultural heritage institutions are included, of course. But there's one aspect that I would like to lift here, and it's good to begin with the definition. Text and data mining is defined in the directive as any automated analytical technique aimed at analyzing text and data in digital form in order to generate information. So from this, it's a very short definition, but it's very clear that this is very broad. The purpose of or the type of information that is generated seems to be irrelevant. It's you analyze information. Well, it's any automated analytical technique in order to generate information. What that information is, the provisions are really agnostic. The definition sort of continues here, which includes both, but is not limited to patterns, trends, and correlations. But it doesn't really matter what it is, as long as it serves the purpose of generating some sort of information that may have theoretical or practical use, and so on. So reading this in the context of Article 3, so of course, for it to apply, the organization needs to carry it out for the scientific purposes, which is also, well, it's not defined, but it has a broad meaning here. But it essentially allows these organizations to carry out text and data mining. In addition, it allows these organizations to store or retain copies for the purpose of scientific research. The provision is Article 3.2. I think makes clear that this includes for the purpose of verification of research results, an aspect that is quite essential in science. It does not provide any time limitation. However, it does recognize that the objective could be to ensure that the research results can be verified. It applies to all copyright protected content except computer programs, and is also mandatory in contractual relations. So essentially, it is not possible to write in a contract that text and data mining is not permitted in one way or another. However, in order for this provision for one to rely on, lawful access is required as a precondition to the act. And this is where libraries and other institutions come in, because in order to get lawful access, at least under the most basic interpretation of this term, and I admit as a copyright lawyer that there is a wild discussion about what that really means, but in its simplest interpretation, it simply means obtaining a license to actually have access to the material. And this is where an opportunity to negotiate various terms and conditions opens up. Potentially that can frustrate certain acts, or that may impose certain other conditions and so on. And with this respect, it's just as a reminder important to bear in mind that because the definition is so broad, it really does encompass all different sorts of activities, as long as it's clear that it serves the purpose of generating information. The way I read this definition, it does not have to result in generating the information, although in science, even information that is not useful is also useful information. That's the whole point of science, to see where one takes one, right? So this is, of course, important to bear in mind. The definitions do matter. And with this in mind, I thought I could I was asked to formulate a couple of best practices. And I think that there's a couple of things to consider. Drawing a little bit on what Georgios was saying, that libraries have no needs because they are operating for the benefit of their patrons. I completely agree with that. But libraries and cultural heritage institutions are certainly stakeholders. They are stakeholders perhaps for the benefit of their patrons, and especially their official mission, because they inevitably fall into the copyright environment. It is essential, I think, to have local copyright expertise, because as the framework becomes more complex, the kind of insights or assessments that may be required on a local level are probably best carried out by a person that is working with copyright issues, as opposed to a general lawyer. It is simply a very nuanced and, in some sense, even maybe esoteric area of law that it just makes sense. Stakeholders or need to orient themselves in what's going on, because that simply affects their activities. In any case, I think it's very important to determine what is the official mission of cultural heritage institutions. Often this is quite clear, and then to ensure that any licensing aligns with this mission, simply not to undermine it, as a tool to help realizing this. Establishing internal licensing principles can be helpful. As another step, mapping out what the law already permits through especially copyright exceptions. If a use is allowed by the law, it's really not necessary to contract it. And in this respect, a contract term that permits what is already permitted by the law has essentially no value in contracting, because, well, it's already permitted. So it doesn't really serve any other purpose than to affirm what is already known. It is essential to map and flag any uncertainty, to ask whether this uncertainty relates or originates from how the copyright exception can be understood. Does it collide the interpretation with the mission of the library? That's really an issue where two different legal frameworks may collide. And it's also important to recall that perhaps well, it's a strategic aspect, of course, but uncertainty of license terms can work both ways. Copyright is a property right, so the default is that one cannot use it unless they are permitted to do it. At the same time, if the law or the legal framework is colliding with other clearly specified acts or provisions of another act, it may tilt the balance in favor of the institution that has the task of realizing their tasks or missions, as it originates from acts that are normally outside of the copyright system, like a Libraries Act, for example. At the same time, it's also possible to determine the rule of interpretation in a contract, and certain terms should be interpreted in favor of the user or in favor of the public interest institution. Another approach may be to build in safeguards through minimum licensing requirements. For example, that the institution, because of its public mission that is clearly specified in the legal framework, cannot do certain things, and this is simply the minimum that it can agree to, or the minimum that it needs to have in order to be able to fulfill its mission. So this is really anchoring the licensing in the mission of the institution. And then from a slightly broader perspective, supporting a culture of sharing and coordinating approaches. Of course, in considering the entire continent, approaches vary between different institutions. This is also an infrastructural aspect, but sharing experiences or creating consortia in order to generate bargaining power or a common approach to what often is the same kind of problem or the same time of tasks can be a good idea, because this way it may also, through collectivism, offer a different edge to determining or obtaining the kind of license permissions that may work the best with the mission of the various institutions. Now, very quickly, running towards the end, I also mentioned that I will briefly offer some insights about the secondary publication right. So what is this? It is not a harmonized type of right, but it's a form of legal mechanism that exists in a number of member states that allows researchers to make their published works available through open access platforms, even when these works are published through subscription journals, for example. So it empowers researchers, and one can say rebalances the bargaining power on the publishing market. More relevantly, it supports self-archiving or what's sometimes known as green open access, and in this way contributes to greater availability of research results. Often it is handled by publicly available research repositories, or many institutions have their own repositories where researchers can upload their papers, potentially making them immune from let's say a journal no longer publishing and essentially disappearing entirely from the research community because nobody publishes there anymore, for example, and so on. It's a mechanism that also strikes a balance. It's sort of placed on the intersection between publishers, scientific publishers mainly, universities and financing institutions, and then researchers. So it really tries to address concerns arising from or new policies that are related to making research available open access and across borders to as much a big audience as possible. The degree to which these interests can be balanced or are balanced does depend a little bit how an SPR is conceptualized. Now, it's called the right, or SPR. The R stands for right, but it can be designed in different ways in the copyright system, as a right indeed, as a rule of copyright contract law and interpretation aspect, or as a copyright exception as well, which is really the more unusual one. But all of these things will affect its qualification. So there's a number of things that a secondary publication right consists of, or it has essential or key variables. In particular, what type of scientific output it needs to cover, whether public funding should be a requirement for the secondary publication right to apply, and if so, to what extent, or what extent of the public research for public funding in that case, which version should it apply to, the author accepted manuscript or an earlier draft or the version of record? Should there be an embargo period between publication in the scientific outlet and the ability to rely on the secondary publication right, and what uses should it cover, such as should it only be restricted to non-commercial use? Can it incorporate commercial use, including commercial parties being able to access that kind of right, and so on? And I don't have the time to go through this table, but essentially I think already there are 6 SPRs existing in 6 different member states. The first one was introduced in Germany, the Netherlands, then Austria, France, Belgium, and most recently in Bulgaria. They have slightly different qualities and properties, but essentially they all amount to the same thing in the sense that they try to make publicly funded research available to as broad an audience as possible, even though it has been published in a scientific outlet. Now, this is, of course, something that is being debated in copyright circles, also in Brussels. So if this is something that you consider to be interesting, there is a big study that was carried out by us at EVIR and in KU Leuven in Belgium and Sant'Anna in Pisa in Italy, and a consultancy firm at PPMI in Lithuania. There's a link there. But this is something that may potentially form copyright dialogues in the coming time. Thank you so much.
Thank you very much, Kacper. Thank you very much. We are really honored to be joined by truly distinguished experts in the field. We can continue with Anne Bergman-Tahon with the third part, cross-border use of copyrighted materials, challenges and solutions. The floor is yours, Anne. Thank you.
Thank you. Do you see my screen?
Yes, we can see your screen.
Okay, thank you. Well, thank you for the invitation, and I'm gonna try to stick to the requested intervention that was to be based on actual law in the European Union. So I'll start with the, I don't know, okay, how do I, well, I start with the principle. I think it was said by other speakers. The authors have the exclusive right of reproduction, communication to the public, and distribution. And they assign those rights to the publisher so that the publisher can publish a book and then exploit them in order to generate revenues. The license, unlike the exception, which have a national scope, the licenses can cover any uses in any territories. And I just wanted, I put it in the slides, but in the chat, but I wanted to add also that when one refers to the Charter of Fundamental Rights, it is all the articles that have been mentioned are of course correct, but there's also an Article 17, and it's a fundamental right of property, including intellectual property. So I think that in copyright is all about balance, and it's not just one parties and not the others. So let me go to the assessment. How do we assess exception in the European Union? It was, we have to reach a balance, and this balance is best done through the 3-step test of the Berne Convention and Article 9.2, and it has to be certain special cases. They should not conflict with the normal exploitation, nor unreasonably prejudice the legitimate interests of the authors. So this is how the EU would, well, sorry, I have a little trouble in moving my slides. I think one thing which hasn't been raised in this webinar is the fact that all across Europe we have many genres of books and many different types of libraries. When we talk about books, we have, of course, scientific and academic books, which are often which were discussed, but we have also educational books, so also called textbooks, and trade books that include children's books. And the libraries lending or giving access to those books are different types of libraries. So it would be a little bit awkward if we had the same rules applying to all the libraries and to all the books. When it comes to both trade books are largely the books you can buy in bookshop. Trade books and educational books are often used only in the country where they are published because of the language. Of course, we have some countries where the language are spoken on both sides of the border, but in most countries in Europe, the books that are being used are the books published in that language. With licenses, of course, those books can easily be acquired in any of the European countries. And now I'm trying to move to the next slides. I haven't been as exhaustive as Kacper as far as the exception. I really took only the exception that were really only for libraries. I could have mentioned text and data mining, the educational exception, and the orphan works exception. But I focus on those three. The first one is the directive on public lending right and rental rights. The directive was passed first in 1992, and it was consolidated later in 2006. The member states can derogate from the exclusive right, but it is clear that at least authors must obtain a compensation for this lending. It is quite important that, and I'll come back to that later, that several decisions of the Court of Justice have made it clear that you cannot at minimum. So then in 2001, we had the so-called directive, Information Society Directive, and then there were two main exceptions for libraries. One about the right of reproduction, which says that you can do specific act of reproduction made by publicly accessible libraries, and those acts have to be for no direct or indirect economic or commercial advantage. And then you have another exception, which the 53N, which allows libraries who have digitized works and for which the works have not been subject to purchase or licensing terms, and that they are contained in the collection, to give access. But clearly, this is a very clearly designed exception, as the access can only happen within dedicated terminals in the premises of the establishment. Then we come to 2019 and the Digital Single Market Directive, and then we have two sets of exception. And again, indeed, I could have put text and data mining and the educational exception, but I decided to focus on those two. It's the preservation, it's the reproduction right, in order to allow cultural heritage institutions to make copy of works that are permanently in the collection. I heard that there's a risk of 21st century black hole because of this legislation. Well, actually, one thing that wasn't said before is that in every European country, except in the Netherlands where it is voluntary, but in all other European countries, there's something called legal deposit, where publishers who are publishing books in one country have to deposit with the national libraries copies of their books. The national libraries is then entitled to make digital copy for further for use within either their institution or for the future. So I don't think that the 20th century black hole is even a foreseeable thing. And then what I wasn't going to speak about that, but I think I need to comment on what Kacper said. I mean, it is clearly Article 6 is clearly an exception to the reproduction right. It's not an exception to the communication to the public right. So I think that this is a matter to allow libraries also to use services from other countries when they come to cultural heritage, and it was very clear when the directive was negotiated. Another set of provision that affects libraries are the art of commerce, and of course, it comes from a very long conversation that publishers, authors, and libraries had together for many years, where both authors and publishers agreed that if they were not commercially exploiting a work, that they could be licensing them for libraries and for non-commercial purposes, and that if there were no collective management organization representing those rights, we were given the example of pins, which may not be represented by any collective management organization, the people who've made pins. In that case, they could trigger an exception. There can be very good reasons for a license not to be granted because there's not enough security about commercial uses of the work, or whether the resources provided by the member states are insufficient. So I would agree that it would be better to have licenses, but there may be reasons for not to have a license. And then allow me to say a few words about the Court of Justice interpretation of the exception. Let's remember that only the court can interpret European legislation. So I mentioned it earlier, there have been several decisions about the required remuneration against a number of member states, including my own, Belgium, who had decided that they would exclude public library from the remuneration, and the court said, no, you cannot exclude all public libraries from paying a remuneration, at least to the authors. Then we come to the very much commented VOB ruling. And in the VOB ruling, there are two elements of the ruling. The first one, which was mentioned earlier, which says that indeed the lending of a digital copy of a book, and we are talking of a ebook put on the market by a publisher, that lending should be allowed under one copy, one loan. But there's a number two. And the number two of the ruling says that you cannot preclude member states from subjecting the digital copy of the book made available by the public library to have been put into circulation by the first sale or ownership of that copy in the European Union by the rights holders. Hence, allowing the rights holders not to give access to the book as soon as it's been published, in order to allow a commercial exploitation. I heard that there was no harm to the rights holders, the author and the publisher, when we have a number of studies that claim the opposite. And the German study that was mentioned and criticized was actually made in agreement with authors, publishers, booksellers, and librarians. So I think that we should pay attention to its finding as well. There's another decision of the Court of Justice that was the Darmstadt ruling. It was a ruling about books from horticulture that were digitized and made available within the library, although there were also ebooks, and the court did say that they were allowed. However, those copies could only be made available by means of dedicated terminals within the establishment. And I will tell you that also, and this is not in the EU, but this is in the US, where we often look at solution. Also, the two courts decided that the digitizing of books and the lending of those books by the Internet Archive was not fair use. So wait, I have to go a little. within the time, yes. So let me go into the licenses, the pragmatic solution. We all know that the Dutch are very pragmatic, and that after having sued the publishers and Stichting Leenrecht, which is the organization who carries the distribution of the money that the states or the in the Netherlands, sorry, it's the libraries who are paying the lending. They sat together at a table and they formalized their agreement, and they formalized it in a covenant that was published in 2018. And the covenant says that you can read it, but it says basically that you are allowed to withhold the titles for a period that can be no longer than 12 months, or when this period, this windowing period is over, then you should provide the library with a more flexible solution than you would have provided with the solution which was decided by the European Court of Justice. So the idea is that you can commercialize your book and in bookshop for a period between 6 and 12 months, but afterwards you have to provide a solution such as simultaneous users, and that has been formalized by the legislator in the Netherlands. Then I have two other examples which I failed to put on slides, but I will send to Daphne and she can share them afterwards. You have the French system, which is a virtuous system because buy from wholesalers, they buy directly from bookshops, so allowing the entire ecosystem to function. They get a license through the bookshop and they can choose their favorite model. It can be one-to-one, it can be simultaneous. There are now 5,000 libraries in France participating in the system, which is called Prêt numérique en bibliothèque, PNB, and they have access to 240,000 titles. They have also in agreement with all parties, decided that if your library within a network, you can mutualize your not just your acquisition, but also your accesses. Another example, which is quite interesting, is a Danish example. It's Iriolen. I would say it's more about audiobooks than it is about ebooks. There has been a long discussion in Denmark, and after that they have agreed to a system, and the system is as such. The library get a budget to acquire ebooks, but also to pay for each loans, meaning that the libraries are managing that budget because they pay per loans and they carefully manage that budget. Authors receive royalties from publishers for the sale, and then they receive the paper loan. There's also for certain publishers some annual fees. So this is a system which has been supported now by all parties because it allows a reasonable organization of the lending. So if we go into the pragmatic answer, obviously it is, I would say, the licenses. I mean, we have exception that will allow you to use a book for very specific purposes, and licensing can cover additional use, and those uses can be necessary for your patrons. Unlike exception, except two exceptions in the 2019 directive that have created that for the exception for education and I don't remember the other one, but the art of commerce, yes, sorry. You are only entitled to exercise this exception within your own territory. Unlike exception, licenses can be multi-territory, they can be in Europe, in the EU, and outside of the EU, and they can cover any type of use that you can agree with the rights holders. Licenses, they allow the remuneration of rights holders and they allow the users to use the book and the libraries to serve their patrons. As I mentioned in the example from the Netherlands or France and Denmark, for licenses, you can lend simultaneous time the same book. So you don't have to buy an enormous amount of bestseller at the moment of publication, but you can serve more than one user at a time. So I think licenses are flexible and they complement the existing exception. With that, I think that I have taken less than the time I was allowed, but that will allow for some question. Thank you very much. And thank you for the invitation.
Thank you very much, Anne. Thank you all for your presentations and the valuable insights. Would anyone like to ask a question at this point? You can raise your hand. I can see in the chat that there are a couple of comments made and some replies have been given.
Maybe if you allow me, Daphne, when you look at the, I think that one thing we should be doing together, authors, librarians, publishers and librarians, is to ensure that the member states are providing sufficient budget for libraries, both to function and to acquire works. We have figures that in the best case scenario for trade publication that are publications, so as I said, you can find in bookshops of fiction, non-fiction, children's book, the library acquisition is about 5% of the total turnover of the sector. In Greece, it's less than 1%. And I think that the thing we could do together that doesn't prevent us to eventually ask for exception or in the case of publishers, of course, justify the licenses is to ask for more money for libraries functioning, because I think that if we want people to read and to have access to books, I can only speak of books because that's the category of work that I represent, the governments have to provide libraries with sufficient budget. I think that in many countries in Europe, it's a disgrace, the amount of money which is allocated for library, both for their functioning and their acquisition. So I hope that this is something we can agree together with the librarians.
Thank you very much. There is a question from Karen Barner. I would like to hear experience with from the experts, experiences with digital ancient manuscripts and unique private sources of images with cultural heritage content. There is also a link shared from her site. Would anyone like, from our experts, would anyone like to take the floor and
I mean, before I let maybe Kacper,
yes, please.
But just that manuscript, there are good chances that they're no longer protected by copyright. So that would be a different question. And private letters, they may be data protection information.
Thank you.
I can jump in here. I think it's what Anne mentioned is roughly really what is the case. Obviously, there can be, it's not copyright legislation, but some form of additional protection of cultural heritage, and even European countries have these kind of provisions or specific acts to exactly to protect or to ensure that material that let's call it ancient. I think it's a good word because it sort of implies it goes a very long time back, historical type of material can be sometimes regulated by specific acts for this purpose, and often the intention is to preserve it or that it needs to be handled in one way or another. As to images, yeah, I think it's really what Anne addressed there. Perhaps from a copyright perspective, of course, there will be a question depending on when it was taken or if it was made available. Availability isn't really a condition for protection, as Eleonora also discussed. The moment it's created, protection subsists, but essentially, depending on what category of photograph it is, because there's two different ways of protecting photographs as a copyright work and as by related rights, which would normally offer a shorter form of protection, but anything longer than 70 years after the death of the author is at least not a copyright question. It can certainly be a privacy question or a publicity right aspect as well, if this is what the national jurisdiction has. But these are generally questions that aren't regulated at EU level as such in a detailed manner, I think. Thank you.
Thank you very much. Does anyone have any other question at this point?
I can add, if I may, I've seen there's a comment from Quentin de Chandelier regarding the three-step test, which is a great observation. So indeed, there is something called the three-step test that affects how copyright exceptions can be treated or should be treated, and at the same time, it has given a rise to a debate or concern, even because the CJU itself has treated this provision. So it's Article 5.5 of the InfoSoc Directive, and it applies. It's an umbrella provision covering all of the exceptions. It has not always been applied by the CJU. By the European Court, and that has sort of sparked a debate as to whether, well, what's the relevance of this provision, what purpose does it serve, and in a number of cases, the court has also said that, well, if the conditions of an exception are satisfied, then the three-step test does not need to be applied. But in another case, has applied these steps. So it's really it's a gray area. Not every member state has implemented the three-step test either. Sometimes it's been used as an interpretative tool to further tweak the copyright exceptions when they are formed for the purpose of the national legal system. So it is at the European level exists there, but that the court is treating it in various ways. I think my main message really was to sort of indicate that while these rules do exist, the court is also changing the approach to the exceptions. So recognition of them as user rights, entrenchment of the fundamental rights aspects in the copyright system, and suggesting that the effectiveness of an exception needs to be ensured. So that's really how I just called it as a short form purpose of interpretation, but essentially that's what it amounts to. Ensuring the effectiveness of an interpretation of a copyright exception needs to be ensured is really a departure from this approach that we have seen previously and in the early cases of it. And I think that some of the flexibilities, the way they are designed in the new copyright directive from 2019, so the fact that they are mandatory in contractual relations, that every member state needs to have them, is also a clear signal that we want exceptions to have a slightly different form than what they used to have in the old directive from 2001. Thank you.
If I may just add,
Of course.
I mean, if not every member state has implemented the three-step test, however, every member state is signatory to the Berne Convention, and the three-step test is part of the Berne Convention. So every member state has to assess the exception in light of the three-step test.
Of course.
And then the court decides whether the assessment has been correct or not, but that's up to the court then.
Should I jump in here, or if I may? Oh, that is also correct.
Of course.
But of course, in the Berne system, the three-step test is only an umbrella clause concerning the right of reproduction. And unlike the InfoSoc directive or the DSM directive, the European legislation, the Berne Convention doesn't really itemize 22 different exceptions, and on top of that, layer a three-step test. So I'd say that the function of the test is different in international copyright law compared to how it works in the European framework. And as mentioned, the European Court is not always consistent in its way of approaching the three-step test. So there's a couple of question marks there, I would say. Which is exactly why libraries should also have a copyright competence locally. These are difficult questions, I must admit that.
Would love to continue the conversation with Kacper on that matter, but I think that we have reached the time.
It is true. It is true. We have reached the time. Thank you very much all for your comments, resources, links shared in the chat. Of course, for your participation. We were very honored having you here with us. Thank you all for attending the session. This was very enlightening for all of us. We appreciate your time. Just for your information, that you will receive the presentations shared during the webinar very, very shortly in your email. Also, the recording will be uploaded on the website, which was indicated in the chat as well. Please, if there is any question or feedback or something you would like to share with us, please feel free to reach out to me. Yes, thank you. Thank you all very much. Have a nice day ahead. Thank you. Bye-bye.
Thank you so much.
Thank you. Bye-bye.
Thank you, Daphne, for organizing. Thank you
Thank you.
for inviting us.
Thank you. Bye-bye.